Okay, stop and frisk section of criminal procedure. Page 281, Illinois versus Wardlow, 2000 case. The Chief Justice Rehnquist delivered the opinion of the court. Respondent Wardlow fled upon seeing police officers patrolling in an area known for heavy narcotics trafficking. Two of the officers caught up with him, stopped him, and conducted a protective pat-down search for weapons, discovering a .38 caliber handgun. The officers arrested Wardlow. We hold that the officers' stop did not violate the Fourth Amendment to the Constitution. That's the holding. The facts as follows. On September 9th, 1995, Officers Nolan and Harvey were working as uniformed officers in the Special Operations Section of the Chicago Police Department. The officers were driving the last car of a 4-car caravan converging on an area known for heavy narcotics trafficking in order to investigate drug transactions. The officers were traveling together because they expect to find a crowd of people in the area, including lookouts and customers. As the caravan passed 4035 West Van Buren, Officer Nolan observed Respondent Wardlow standing next to the building holding an opaque bag. Respondent looked in the direction of the officers and fled. Nolan and Harvey turned their car southbound, watched him as he ran through the gangway and an alley, and eventually cornered him on the street. Nolan then exited his car and stopped Respondent. He immediately conducted a protective pat-down search for weapons. Because of his experience, it was common for there to be weapons in the near vicinity of narcotics transactions. During the frisk, Officer Nolan squeezed the bag Respondent was carrying and felt a heavy, hard object similar to the shape of a gun. The officer then opened the bag and discovered a .38 caliber handgun with 5 live rounds of ammunition. The officers arrested Wardlow. Nolan and Harvey were among 8 officers in a 4-car caravan that was converging. Is this like a duplicate? I'm just going to read this to make sure it's a duplicate. It is kind of a duplicate, except individual's presence. Did we get to that? It's really not a duplicate paragraph. Okay. Nolan and Harvey were among 8 officers. No, that's right. Officers traveling together. Okay, so we got to that part. It was in the context that Officer Nolan decided to investigate Wardlow after observing him flee. An individual's presence in an area of expected criminal activity standing alone is not enough to support a reasonable particularized suspicion that the person is committing a crime, but officers are not required to ignore the relevant characteristics of a location in determining whether the circumstances are sufficiently suspicious to warrant further investigation. Accordingly, we had previously noted the fact that the stop occurred in a high crime area among the relevant contextual considerations of the Terry analysis. In this case, moreover, it was not merely respondent's presence in an area of heavy narcotics trafficking that aroused officers' suspicion, but his unprovoked flight from noticing the police. Our cases have also recognized that nervous-evasive behavior is a pertinent factor in determining reasonable suspicion. Headlong flight, wherever it occurs, is the consummate act of evasion. It is not necessarily indicative of wrongdoing, but it is certainly suggestive of such. In reviewing the propriety of the officer's conduct, courts do not have available empirical studies dealing with... The courts do not have available empirical studies dealing with the inferences drawn from suspicious behavior, and we cannot reasonably demand scientific certainty from judges or law enforcement officers where none exists. Thus, the determination of reasonable suspicion must be based on common sense judgments and inferences about human behavior. We conclude Officer Nolan was justified in suspecting that Wardlow. Reasonable suspicion must be on common sense inferences about human behavior. He was justified in suspecting Wardlow was involved in criminal activity and therefore in investigating further. Such a holding is entirely consistent with our decision in Florida v. Royer, 1983, where we held that an officer without reasonable suspicion or probable cause approaches an individual, the individual has a right to ignore the police and go about his business. And any refusal to cooperate without more does not furnish the minimal level of objective justification needed for a detention or seizure. But unprovoked flight is simply not a mere refusal to cooperate. Flight, by its very nature, is not going about one's business. In fact, it is just the opposite. Allowing officers confronted with such flight to stop the fugitive and investigate further is quite consistent with the individual's right to go about his business or to stay put and remain silent in the face of police questioning. Respondent and Amici also agree that there are innocent reasons for flight from police, that therefore flight is not necessarily indicative of ongoing criminal activity. This flight is undoubtedly true, but does not establish a violation of the Fourth Amendment. Even in Terry, the conduct justifying the stop was ambiguous and susceptible to innocent explanation. The officer observed two individuals pacing back and forth in front of a store, peering into the window and periodically conferring. All of this conduct was by itself lawful, but it also suggests that the individuals were casing the store for planned robbery. Terry recognized that the officers could detain the individuals to resolve the ambiguity. Now, that's the end of the majority opinion. Justice Stevens, with whom Justice Souter, Ginsburg, and Breyer joined, concurring in part and dissenting in part. The state of Illinois asked the court to announce a bright-line rule authorizing the temporary detention of anyone who flees at the mere sight of a police officer. Respondent counters by asking us to adopt the opposite per se rule, that the fact that a person flees upon seeing the police can never by itself be sufficient to justify a temporary investigative stop of the kind authorized by Given the diversity and frequency of possible motivations for flight, it would be profoundly unwise to endorse either per se rule. The inference can be reasonably drawn about the motivation for a person's flight. Rather, will depend on the number of different circumstances. Factors such as time of day, the number of people in the area, the character of the neighborhood, whether the officer was in uniform, the way the runner was dressed, the direction and speed of the flight, and whether the person's behavior is otherwise unusual might be relevant in specific cases. This number of variables is surely sufficient to preclude either a bright-line rule that always justifies or that never justifies an investigative stop based on the sole fact that flight began after a police officer appeared nearby. Still, Illinois presses for a per se rule regarding unprovoked flight upon clearly seeing an identifiable police officer. Unprovoked flight, in short, describes a characteristic describes a category of activity too broad and varied to permit a per se reasonable inference regarding motivation for the activity. While the innocent explanations surely do not establish that the Fourth Amendment is always violated whenever someone is stopped solely on the basis of unprovoked flight, neither do the suspicious motivations establish that the Fourth Amendment is never violated when a Terry stop is predicated on the fact alone. For these reasons, the court is surely correct in refusing to embrace either a per se rule advocated by the parties. The total of the circumstances, as always, must dictate the result. Totality of the circumstances. Guided by the totality of the circumstances test, the court concludes that Officer Nolan had reasonable suspicion to stop respondent. In this respect, my view differs from the court's. The entire justification for the stop is articulated in the brief testimony of Officer Nolan. Some facts are perfectly clear, others are not. This factual insufficiency leads me to conclude that the court's judgment is mistaken. The dissenters here elaborated that they found that record as a whole failed to establish reasonable suspicion, considering that it did not show whether any vehicles in the caravan were marked, whether any other officers were in uniform, where the intended destination of the officers was in relation to where defendant was seen, whether the caravan had passed before defendant ran. The state, along the majority of the court, relies as well on the assumption that this flight occurred in a high crime area. Even if that assumption is accurate, it is insufficient because even in a high crime neighborhood, unprovoked flight does not invariably lead to reasonable suspicion. On the contrary, because many factors providing innocent motivations for unprovoked flight are concentrated in high crime areas, the character of the neighborhood arguably makes an inference of guilt less appropriate rather than more so. Like an unprovoked flight itself, presence in a high crime neighborhood is in fact too generic and susceptible to innocent explanation to satisfy the reasonable suspicion. Yeah. Because these people are ignorant, right? Not kindergartners.